Imagine getting a ticket, not for speeding, not for running a stop sign, but simply because a cop didn't like something you said. Then, before you know it, the same ticket now becomes the police officer's excuse to pat you down and search you. Sound legal? I'm Jeff Hampton, former prosecutor turned the people's lawyer. And in today's video, I'm going to cover number one, how cops try to use citations, simple tickets, as a way to trap you into a search and what you can do to stop them. And then number two, if cops try to get you out of your car doing a routine traffic stop and give you a citation, are they allowed to search the inside of your car? Stick around, because knowing your rights in this situation could be the difference between going home free or being caught in a legal nightmare. Situation number one, cops write you a ticky-tack ticket and then want to use that ticket as an excuse to search you. Normally, if cops place you under arrest, they are permitted to perform what's known as a search incident to arrest. But sometimes cops don't want to arrest you, or maybe they can't find anything to arrest you for, so they just write you a ticket. Do cops have the same authority to perform a search incident to a ticket? In order to understand what police can and can't do here, we must look at the Supreme Court case of Knowles versus Iowa. In Knowles, an Iowa police officer issued Knowles a ticket for speeding 43 miles an hour in a 25 mile an hour zone. Iowa law permits an officer to make a citation instead of an arrest for any criminal offense that is bailable under Iowa law. Iowa law at the time also provided that deciding to give somebody a ticket instead of arresting them did not take away a police officer's right to search incident to the ticket. The Iowa Supreme Court had completely interpreted that law as giving police officers the authority to walk around issuing tickets to people, and they would have the same ability to conduct a full-blown search of either the person or their car, just as they would if they had decided to arrest them and perform a search incident to arrest. So in other words, it created a whole new standard of search incident to ticket. Without either consent or probable cause, the police officers in this case decided to search Knowles and his car, and of course they ended up finding a little bit of marijuana and a pot pipe, so they arrested him. Knowles was then subsequently convicted, and the Iowa Supreme Court upheld this conviction. Now, the big issue for the Supreme Court, where they had to answer here, is whether or not an officer is allowed to search you and or your vehicle when they only issue a citation rather than deciding to arrest you. Fortunately, the United States Supreme Court, by unanimous decision, reversed Knowles' conviction, and they determined that the actual search incident to ticket was a violation of the Fourth Amendment to the United States Constitution. In a rare opinion, Chief Justice Rehnquist actually reasoned here. He said that the only two reasons why an officer would need to conduct a search incident to arrest was, number one, the need to disarm the suspect in order to take him into custody, or number two, the need to preserve evidence for later use at trial. He then said neither one of these situations is present whenever a police officer only issues a ticket. So are we done? Does this mean the Knowles decision will stop cops? Not exactly. Here's the problem. Even though the Supreme Court in Knowles made it clear that cops do not have the ability to perform a search incident to ticket, the problem is cops may then claim they had reason to believe you might have had a weapon on you, or you create some type of situation where their officer safety is at risk. If cops can justify articulable facts that establish that you might have evidence or a weapon on you that now places them in fear for their officer safety, they may be able to use this to justify a pat-down search. I've covered Terry stop and frisks exhaustively on some of my previous videos, but as a quick reminder here, the landmark case of Terry versus Ohio was decided back in 1968, and it really changed the landscape of the Fourth Amendment because it established police officers could conduct what's known as stop and frisk procedures whenever they're able to establish reasonable suspicion that somebody may be involved in criminal activity. Basically, a Terry stop and frisk allows police officers to make a brief detention, pat somebody down for weapons and for their officer safety, even though they don't have probable cause of an actual crime taking place. This case set a brand new standard that essentially allows police officers to detain you and search you if they can establish reasonable articulable facts that you may be armed and dangerous. This is where it allows officers to pull out the whole officer safety standard to now be able to search you. In theory, the Supreme Court established this standard in order to preserve officer safety. But in practice, some officers abuse this officer safety as a reason to justify illegal searches. We're now going to apply the Terry standard to our ticket situation. So if officers are going to claim that you are detained while they're writing you this ticket, they're now going to be looking for anything you say, anything you do, anything at all that will now allow them to justify doing a pat-down search on you for officer safety. This brings me to a few pro tips you can use right now in order to stop cops from using a ticket to be justification to search you. Number one, don't argue with the cops about why you received the ticket. Why? Cops are looking for anything that you say or do as justification to now perform a pat-down search on you in the name of officer safety. Now, that's very difficult for them to do if you don't give them anything. That leads me to my next tip. Number two, exercise your right to remain silent. If a cop insists on writing you a ticket, stay calm. But if he comes at you asking you questions and he goes fishing hoping you will bite, remember, all you have to say is, "Officer, I exercise my right to remain silent, and I will not answer any questions unless my attorney is present." Then remain silent. These tips are critical to stop cops from using anything you say or don't say as a pretext to then being able to search you and pat you down, all in the name of officer safety. Now, I have personally seen police officers say that if they have reason to believe you have any evidence on you related to the same offense they're citing you for, they will use it as an excuse to search you. So how do cops get away with this argument? Here they are relying upon the very important case of Cupp versus Murphy. In this case, Daniel Murphy had been accused of murdering his wife. His first mistake was that he voluntarily went to the police station for questioning. And when he got there and he sat down, the police started looking at his fingers and they thought they found a blood spot. Police then immediately asked Murphy to conduct fingernail scrapings off of his hands in order to preserve the evidence. And of course, Murphy refused. Police then forced Murphy to provide samples without a warrant, and the test came back positive for blood, skin, and fabric that came from the victim's nightgown. Murphy was then convicted based upon this evidence. He then later appealed it and challenged it, claiming that the search and seizure was unconstitutional. When Murphy appealed his conviction, the Supreme Court said the police did not violate his Fourth Amendment rights because the need to preserve potential evidence that could have easily been destroyed justified the limited search. The court recognizes that the evidence in question, fingernail scrapings, were easily destructible and that the police had a legitimate interest in preserving it. Why is this case important? Because police rely on this court ruling as a basis for them to claim and justification that they can take evidence, physical evidence from someone without a warrant. But we have to be careful here because that's not exactly what Cupp versus Murphy held. It's important to understand it was a limited holding. In Cupp versus Murphy, it basically says the police do not have to have a search warrant in order to be able to take physical evidence from a suspect if and only if, number one, they already had probable cause of the crime being alleged. Number two, the evidence must be easily destructible. And then number three, the intrusion of the search must be minimal. Now I want to pause for a moment and ask you, did you know that scammers can literally steal your home out from underneath you? The FBI calls it house stealing, and it's a growing real estate scam that is targeting American homeowners. Here's how it works. Criminals forge your signature on one document, use a fake notary stamp, pay a small fee, and file it with your local recorder's office. And just like that, your home title has been transferred out of your name. Then they take out loans using your equity as collateral, or even sell your property behind your back. And you won't even know it's happening until you start getting collection or foreclosure notices. So let me ask you, when was the last time you checked your home title? If you're like me, the answer is never. And that's exactly what the scammers are counting on. That's why I trust Home Title Lock. Their $1 million triple lock protection helps keep your home and your equity safe. Here's what you get: immediate 24/7 monitoring of your property, urgent alerts if there are any changes, and if fraud should happen, their US-based restoration team will spend up to $1 million to fix the fraud and restore your title at no additional cost. And here's the best part: I've teamed up with Home Title Lock to give you a free title history report so you can find out if you're already a victim and access to your personal title expert, a $250 value just for signing up. Go to HometitleLock.com and use promo code HL250 or click on the link down in the description. That's HometitleLock.com, promo code HL250, and get the peace of mind and protection you deserve. So how does Cupp versus Murphy apply specifically to cops using tickets to search you? A classic example of this is a shoplifting case. In many states, if the amount that has been shoplifted or alleged to be shoplifted is low, a small amount, cops cannot actually arrest that individual. They can only issue them a ticket. But if cops have a reasonable, articulable suspicion that someone has stolen merchandise on them, they can now perform a search because it is evidence of an alleged crime. Now, how exactly is this different than what Knowles ruled with the Supreme Court? The possession of stolen items is different than Knowles because here we're talking about a different search warrant exception known as exigent circumstances. If police have reason to believe someone has evidence on them, they can now claim it's an emergency situation that justifies them being able to conduct the search. Otherwise, they're going to argue that the evidence could have been destroyed or thrown away. So what have we learned from this situation? Here's the key rule. An officer cannot use writing you a ticket as a basis to then search you unless you open your mouth or do something to give them a reason to believe you're either holding evidence of some sort or if you have done something to now place their officer's safety objectively at risk. If you exercise your right to remain silent and stay silent, it will be very hard for a police officer to justify it. Situation number 2. What if cops pull you over for a traffic stop, get you out of your car, then write you a ticket, and then want to use that ticket as a basis to then search your car? Is this legal? How can you protect yourself in this situation? This brings us to the United States Supreme Court case of Arizona versus Gant. In this case, Rodney Gant was pulled over, taken out of his car, and alleged to have committed the crime of driving with a suspended license. The cops then handcuffed and placed Rodney in the patrol car. They then claimed they could use his detention, being in the patrol car, as a basis to then search his vehicle and use anything they find against him. After the search, the officers found drugs in the car and he was later convicted. Now the issue here is if cops get you out of your car and they either cite you or arrest you, can they then use that citation or arrest as a justification to then search your car when you have no immediate access to your car? The Supreme Court ruled in a very important decision that the actual search of Gant's vehicle was illegal, primarily because he had no access to his car. So there was no chance that the police could have claimed he had some sort of weapon or that he had any evidence at all that was related to the crime for which he was being detained, which was driving with a suspended license. In other words, similar to our first scenario we covered earlier, in order for officers to be able to get you out of your car and claim your detention as a reason for them to search your vehicle, they're going to have to prove some exigent circumstance, some specific emergency that places their officer's safety at risk. Either you have some sort of gun in your pants or there's something in the car that's a risk to them, or maybe they can claim that maybe some evidence is being destroyed. Otherwise, cops can't just get you out of the car, write you a ticket, and use that as a reason to search the car. If they really want to do it, they need to take the time and do their job right and get an actual search warrant, then perform the search. Arizona versus Gant was very important because it narrowed the search incident to arrest exception. It now forces cops to articulate a very specific reason to be able to search your vehicle and not just rely upon you being in custody. So how do you stop cops from being able to legally search your car once they have you out of the car? This brings me back to the pro tips you can use to make sure and protect and stop cops from using anything you say or do to justify a search of your vehicle. Number 1, don't argue with cops about why you're receiving the ticket. Why? First of all, under the Supreme Court case of Pennsylvania versus Mims, cops can almost justify any reason to get you out of your car in order to perform a search if they can claim some type of officer safety issue. Second, cops are always looking for anything that you say or do to justify being able to conduct a search, all in the name of their officer safety. But if you don't say anything or do anything, it's hard for them to justify it. Which is precisely why you should then, number 2, exercise your right to remain silent. If the officer gets you out of the car and starts sizing you up and goes on that fishing expedition we talked about earlier, asking you question after question, which they are trained to do, you need to remain calm and then stop for a moment and look at the officer and say, I exercise my right to remain silent and I will not answer any questions unless my lawyer is present. Then remain silent. These tips are critical to make sure and know and follow so that you can stop cops if they try to use a ticket to search you or your car. Now, what if you exercise your right to remain silent, then an officer looks over at you and claims your silence is somehow an admission of your guilt? Check out this next video where I break down how cops try to get around your right to remain silent and how you can stop them. See you over there.